Good. Okay. All right, good evening, everyone. Welcome to the zoning board of appeals meeting for Tuesday, June 4th. If Lisa, if you could call the roll.
Brown,
Present.
Hendricks,
Present.
Nibbs,
Here.
Marshall, present, Stein, here.
All right, first thing is approving, the minutes from April 9th. We can just, disregard the May 7th because there was no meeting. Did anyone see anything in the minutes that needs to be, corrected or? I did address.
No.
No? No. Right.
I make the motion that we approve the minutes of the
So,
April 9th meeting.
also. All those in favor? Aye. All right. Old business, this is case number 874, an administrative review of zoning administrator determination regarding a short-term rental on the first floor of at 215 West Mitchell Street. Would you like to give us a little background?
Sure. So on January 24th, 2024, the applicant submitted a single application for two short-term rental units at 215 West Mitchell Street, one on the first floor and one on the second floor. The second floor unit was complete and ready for inspection at the time of application, and the first floor unit was not yet complete. Per ordinance 794, short-term rentals are a permitted principal use in the B3 district. And per section 1719 of this ordinance, the standards for short-term rentals states for those zoning districts where short-term rentals are a principal permitted use, short-term rentals shall be located above the first story of the principal building. Based on this information, the second floor unit was approved and the first floor unit was denied. The applicant is requesting an administrative appeal of this determination.
Does anyone have any questions for Lisa about the case? Could you maybe talk about, I know since I've been on the ZBA, I've only had one administrative review. It's kind of different than what we normally do. So could you kind of explain how that differs from, when someone applies for a variance?
So typically a variance, you're looking at setbacks, height, lot coverage, that sort of thing. An administrative appeal is where the zoning administrator has made a determination based on the application and the ordinance as it's written. And they've determined one way or another. If the applicant does not believe that that determination is correct, they can appeal to the zoning board of appeals to request that the board look at their application, what was submitted, the materials used by staff, and that's basically how the determination needs to be made, is off of the information that was available to staff.
Okay. So we're not going through our typical, checklist that we normally do. This is basically, do we agree with the determination or not? At this point, is anyone wanting to speak on behalf of the applicant?
Yes, thank you. My name is Joseph Zayas. I represent the design. You get the microphone.
Thank you.
Okay, I think we got it. Thank you. My name is Joseph Zayas. I represent the Mitten LLC as well as the John and Mallory Powell, who are also here to answer any questions, should you have any. And I guess the first thing I need, first, I guess, let me thank you for your time tonight. I know it's something you do in addition to your everyday jobs, and we certainly appreciate your service in doing so. And the administrator is right in that we're seeking a determination that we should be permitted to run a short-term rental on the first floor because we're essentially a vested use. We're a vested prior use of short-term rentals from the prior ordinance. What that means is that we did work of a substantial character, which is the test to determine when you're a vested use or not. It's not, did you actually run the business? It's not, were you licensed? It's not, did you start the business? It's, did you do work of a substantial character to change the property into whatever you want it to be in this term of short-term rental unit? If you had done that, then you're essentially grandfathered in as a prior as a prior use under the prior ordinance and should be allowed to continue that. Now, one respectful correction I'll make from the zoning administrator is there's no law to support her contention that you're limited to only what she had seen. In fact, the court rules say that if this happens to get brought up on appeal, the record from this appeal will, or from this session here, will be anything that we submitted to you, as well as the minutes from today's meeting. So I respectfully disagree with the zoning administrator that you're limited only to what was before her. That's not really what we're here for today, because it's not as if we would have, you know, as you do in front of a Mr. Law judge, we're allowed to present testimony and evidence. That's not the situation here. So respectfully, I would disagree with that determination, as I don't think it's consistent with the law. And we've submitted to you back in April, pretty lengthy, and I apologize for the length. Pretty lengthy memorandum in support of our contention, and I'll trust that you've reviewed that you've read that, and I'll try not to repeat all of that in respect for your time. The argument really is quite simple. They purchased this building back in 2022 and immediately began doing work on it. They took substantial steps to turn both the top and the bottom floor into a short-term rental. Prior, it was a business on the first floor, residents on the second floor. And they had to turn that first floor business area completely into install bedrooms and bathrooms and all of those things to make it applicable for a short-term rental. Now, as an aside, you may be asking yourself, well, why, if they have the top floor, why don't they have the bottom floor? Well, when they purchased this building, their business plan was to cater specifically to large groups that wanted to bring pets, and so may not be able to get hotel rooms or something of that nature and wanted to be together, family reunions, etc. This building was perfect for that. So they invested substantial sums of money and actually changed the character of the building itself to turn it, did substantial work to change the character to turn it into a short-term rental. Now, under your prior ordinance, it didn't really address short-term rentals. So it's really kind of hazy as to how that was zoned, frankly. That being said, regardless of how you actually read the ordinance, the old ordinance, I think it'd be very difficult to argue that they wouldn't be allowed to run a short-term rental in these three business district. They most certainly would, and they most certainly would both on the first and the second floor. That argument's addressed in my brief. I can certainly go into it further if there's questions about it, but I think that's pretty clear. It's also important to point out, I think, that when they first purchased this building, the first thing they did, in fact, the purchase was contingent on it, zoning be appropriate for a short-term rental. And so they had the real estate agent contact the zoning administrator and say, is zoning appropriate for a short-term rental? And the answer was yes. From there, a whole slew of events, of which I'm not sure I need to get into all the details of delays and hindrances and all kinds of things happened that had the result of the city essentially changing from the old ordinance to this new ordinance right under their noses. And in the meantime, they really weren't allowed to apply or obtain any of the licenses until the city finally let them, after the passage and the implication of the short-term rental ordinance. So I also would respectfully disagree with the zoning administrator when she says they first applied for their license in January of 2024. In reality, they attempted on several occasions, and the city actually accepted their license long before then, but didn't process it because they claimed that they were passing this new ordinance and that they would have to do it under the new ordinance, and then essentially did not fully process the application until the new ordinance passed. Now, there are questions about whether the moratoriums were appropriate. There are questions about due process issues with the application process. I'm not sure we need to get into those tonight, because as a zoning board of appeals, the question before you really is, were they a vested non-conforming use prior to the implication of this new ordinance? And it's important to point out that this new ordinance didn't take effect until January 2024. So then I'll go back to the legal test, and that's cited in my brief, so I'm not gonna bore you with case law. But essentially, legal test is, did they do substantial work to change the character of the building? And if they did, then they're a prior non-conforming use. And they should be allowed to operate as a short-term rental on both the first and the second floor, as they would have been under the old ordinance. Now, there's also an issue of estoppel, and what estoppel is essentially if someone makes a statement, they can be held to that statement, particularly if somebody relies on it. So when they ask the city, is this zoned for a short-term rental? And the city said, yeah, zoned as a short-term rental. Given before the city kind of did the switcheroo on them and changed the standard on them, they're entitled to rely on that statement. So another reason that you may overturn the zoning administrator's decision is because of this estoppel argument that it's not correct legally. But our main argument is very straightforward. It's that they did substantial work under the old ordinance and should be treated as a short-term rental under the old ordinance. And that's all they're asking for today. They're asking for you to reverse the determination of the zoning administrator. You may do so by simply finding, as I have suggested, that they've done work of substantial character under the old ordinance. You can rely on the second appendix that we submitted, exhibits J, V, W, and X, which are building invoices and other things showing the work that was completed. And if you find that, then you make the legal conclusion that since they did the substantial work, they're essentially grandfathered in to the old ordinance, and that they're allowed to operate as a short-term rental. That's all we're asking for today. Does anybody have any questions for me or for the Powells?
I have a question.
Yes, ma'am.
So I thought when you talked about vested interests, you were relying on the prior use of the building because it was a printing business from 1979. So you're saying that that's not what you mean by vested interest. You're saying that regardless of local zoning, absent permits from the city, and do you have a county permit to redo? I know that Marty visited, but I don't know if you got a county permit.
I believe we applied for the permits. We eventually did, yes, have the permits.
Okay, so you can, your argument or position is that without city approval, if you go ahead and do the work, you get to be grandfathered in.
No, that's not an argument.
Well, that's what I heard.
Well, I apologize and I'll try to correct then what I was saying. Our argument is we applied for the permits, and I believe we did actually receive some of the permits. There was a mix-up with the contractor. The Powells will be more than happy to address that if you want them to. But we're in a situation when we just started doing it on our own willy-nilly. Stop us if you can. But the law, the case law, doesn't hinge this on whether or not you had a permit or not. The case law says that if you do work of substantial character to change the actual character of this, then you're grandfathered in. Now, whether or not it was with a permit, there's a whole different enforcement mechanism for that. That's not really what we're here to adjudicate today. What we're here to adjudicate today is whether or not they were vested by the work they did. And under the case law, the test to determine whether they were vested or not isn't did they have a permit, it isn't did they have a license, it's did they do work of a substantial character to actually change the character of it to what they were trying to turn it into. And in this case, they did.
And does this law apply to any kind of change that an individual makes to a building?
I'm not sure I follow your question.
Well, if it applies here, does it apply to a person in a residential area who goes against the local zoning and changes something? And the argument is, well, I did the work, so I get to do it. Or a business that changes the character of a business building.
No, because
I did the work, so you can't fault me.
I apologize, I didn't mean to interrupt you. No, because it only applies when the zoning is changed. So if the zoning would have stayed the same, then this wouldn't have been an issue because they would have had their license.
Okay, and you believe that the prior zoning allowed short-term rentals on the first floor?
Yes, I think that's pretty clear.
Okay.
So, I'm sorry, yes.
Thank you.
So
Can I ask more question too?
I think there's another question.
I have a question. It's like actually.
No, yes, we're just gonna.
Okay.
This.
That's fine.
So I wanted to speak back to the permit,
Sure.
because it's typical in application for permits that any change of use is outlined in that application for permit, and there is a zoning review in the initial review for the permit. There is no documentation of the permit in this package. But it says it was applied for back in 2022. So there should, if we could see that application for permit,
Sure.
that would be very helpful.
She has the factual, well, the reason we're doing this is because she has the factual knowledge of what happened with her permit. There was an issue with the contractor who represented that he applied for it. And because she has that factual knowledge, I'm going to allow Mallory to respond to your question as to what happened there.
Thank you again for your time. I apologize in advance if I am emotional about this. So unfortunately, we worked with a contractor, a local friend, who represented to us that all permits had been pulled. You may have noticed in the packet we included, there is a text message that actually says he had spoken with Lisa. This is in, I believe, November of 2022, and that the permit was approved. We have yet to see that documentation because we made a FOIA request back in, I believe it was April, after the first meeting that we did not attend, and we have paid an almost $700 deposit for it and not seen a single document to date. I do want to also point out as well that beyond having been told by our contractor who represented that he pulled a lot of permits that he didn't, honestly, and we had already moved forward to hiring an architect, and we have a new contractor waiting in the wings because we had parted ways with him because it was very important to us that we followed the letter of the law and that not only was this legal, but it was safe. That before we applied, I believe this was the February ZBA hearing that you guys had, before we had even submitted our application to Lisa, though she did know that there was likely an application forthcoming, though not knowing exactly the pretenses. At the end of the February meeting, there is a moment on the video, it's on the record, where Lisa says that she did issue us a change of use zoning permit. So I would obviously have to defer to Lisa because I have not yet seen the documentation for that, though we have attempted at our best to get it. I actually followed up with Sarah this week to see if there was any chance that we would be getting it ahead of the latest deadline, which they gave us, which is June 26th. And she said that she would work on it, but at the very latest, it would be June 26th. But I think that Lisa would be able to better speak to it just because we were under the impression that our contractor likely had not pulled those permits, even though he had represented that to us. But then when she said on the record that she had done a change of use for the first floor, I think that just adds to the estoppel.
Was that February?
That would have been November so we purchased the house in spring of 2022. In November of 2023, we began our construction. If you guys may recall, coming out of the pandemic, it was very, very hard to get a contractor to start to even look at a project, let alone start any kind of work. The only way that we got our contractor was he was a friend and he was starting a new business. So that was applied for, I believe, in November or October of 2023, and all the work was done in 2023. We had stopped in roughly about June, July or August of last year when we realized that he not only was missing deadlines, but that we could not trust the things that he was assuring us, and he would not produce the permits that we had asked for several times. But I think it's important to note that we had already invited the county in to see where we needed permitting, what needed to be ripped out. Like our intention was to follow the letter of the law. Unfortunately, we were in a situation in a new town where someone took advantage of us. And if we were not in this case, honestly, we probably would be taking action against that contractor. So all of the permitting, all of that issue was dealt with well before we even knew that there was a moratorium, well before the city even represented that we couldn't apply for our license. It wasn't until October of, I'm guessing this is 2023 at this time, where we received a citation for running an illegal short-term rental, which we are not, it was not open. We had still not hosted any guests. That I contacted Sarah because Lisa, I believe, was out on vacation at the time. And we were told that
a moratorium had been passed and I couldn't apply. I tried to apply in October. I tried again in December to apply. I tried to apply the day after the new ordinances were passed because we submitted a petition under the Zoning Enabling Act, which basically put the new ordinances on hold. So above and beyond everything, which is the central point, and I think the best point to make that we are in fact vested, we did apply before the new laws came into effect. What was before the ZA, the full decision is actually included now at the end of the packet, and as you'll notice, it includes 5 pages that weren't included at the front of the brief. And those 5 pages include an application that was paid for with a receipt on January 5th. On January 5th, the new ordinances were not in effect. They were under a petition or an intent to petition until at least January 17th. So not only were we vested, but we applied and paid for it and met all the requirements of the past zoning before the new laws went into effect.
If you wouldn't mind just looking at exhibit A and exhibit, sorry about that, John Powell, 215 West Mitchell Street. If you wouldn't mind looking just at exhibit A and exhibit B, these are the emails between our realtor and Sarah Beck. And I just want to highlight that Sarah Beck confirms correct. The zoning department confirmed that 215 West Mitchell Street is zone B3, which would allow for a short-term rental. This is in April of 2022. That's carte blanche approval from the zoning department. I mean, the reality is we're standing before the zoning board of appeals, asking you to allow us to do something that the zoning department from Go approved. Let that sink in. So, I'd also just like to correct the notion that this was just done on January 24th or January 31st when the determination was made. Again, we submitted on January 5th under the prior ordinance, and we have been corresponding with Lisa since 2022. So the premise that this all just occurred recently is not valid. I see there are some reactions to that statement. If you wouldn't mind, I'll just share the initial correspondence with Lisa that I had. May I give you the document? Thank you. That's October of 2022. I'll add that Lisa directed me to Zach Samples, who I never actually received a call back from. And then he was no longer the city planner thereafter.
So,
Sure.
so what are you, what is the significance of this letter? I mean,
That's a brief correspondence with Lisa establishing the fact that we were in touch with the city from Go at the start of this project. And just as an aside, I mean, you come to a city and you expect bringing a new business that the city would open its arms and welcome you and guide you through the process of what needs to be occurring. And we, again, fulfilled every step that needs to be occurring. But to then have the rug pulled out from under us midway through the project, as Zach Samples is going before city council and planning commission saying we currently have people who are redeveloping buildings right now that we don't want to do that to. And then that's exactly what occurs, is why we're here today.
If I could just return us, our legal argument remains the same, and it's not contingent on whether a permit was pulled or not. I think the context is important, so thank you for your question, and I hope that we've kind of explained what happened. But the legal question is, do we do the substantial work? And I think it's very clear on the record that we did, and you can base your decision on the fact that we did. And when they change an ordinance on you after you've done the work, or when you're in the process of doing the work, that's when this concept of a vested interest comes in. And that's our argument. That's the argument we're making.
So I have a question.
Sure.
Chris, can you turn your microphone?
What distinguishes the work, like, let's say that the structure has 2 stories. What's to say that the main level wasn't just being improved as, like, say, their permanent, home or something, not a rental unit? Like, what makes the work that was done specific to a rental unit and not just
Well, first,
anything else?
sure. And first, I guess there's no evidence on this record to support a contention that they were going to do anything else with it. And to make that factual determination, you need some evidence that they were going to do something else with it. That being said, they have another house. They don't live there. They live in their own home. So there's certainly nothing to indicate that they, did it so they can hang out there. It really has no other purpose other than as a short-term rental. It's not like it could be turned into another kind of business or something down there. And there's certainly
It
no.
could be turned into a long-term.
Okay. Perhaps, but there's certainly no evidence on this record, and that's one thing I would caution you against is it's fine to ask questions, and I welcome the questions and I appreciate them. But you have to have some sort of evidence to support the contention. And we've presented evidence that we're turning this, as well as testimony that we're turning this into a short-term rental, and there's really no evidence to contradict that. So what would stop them? Well, as Mallory stated, there's no kitchen down there, so it really can't be a long-term rental. But there's also certainly no evidence on this record to suggest that it would be. They don't live there. And the question before you then isn't, well, what else could they do with it? The question is, did they make work to turn it into what they could have? Not did they do work that would prevent them from doing anything else with it? I mean, that kind of standard really wouldn't be workable.
Well, if I'm understanding your argument, you're saying the fact that they did work prior to all of this
Right.
is what gives them is what sort of grandfathers them.
That's the interest, correct?
But so I'm just trying to understand, if you talk about evidence, there's no real evidence of what their intent for that space was going to be, correct?
No, that's not correct. I mean, I think it's pretty
What
clear
is the
from.
evidence?
Well, first of all, they have their application wherein they say under oath that they're going to turn it into a short-term rental. That's evidence. There's also the floor plan showing and the business plan showing that they're going to use it as the Knit-In LLC and turn it into a short-term rental. We could also provide for you, emails and other things. But to require us to disprove an intent to use any other use really doesn't. It flies in the face of what the standard is to say you have to disprove an intention to use it for anything else. It doesn't make a whole lot of sense to me.
Well, no, I think it's on you to prove that this is what the space was intended for.
Sure.
I mean, right?
Okay.
So I want to be clear. So my husband and I moved here from Chicago in 2021. We moved here with the sole intent purpose. I already owned the domains for the Knit-In since I believe the summer of 2020. August of 2020 was our first trip up here. We actually looked at 414 North Wakazu, which is a grandfathered use of an STR on the first floor that was allowed under the change of the new ordinance. we obviously showed our intent by emailing, our entire purchase of the property was contingent upon it being approved and zoned appropriately to be an STR. I do also want to mention that in March of 2023, I filed a business license, paid for it. And that business license was actually held back and no one contacted us, but both Lisa and Sarah Beck saw it. And that was only given to me in October when I got a false citation for running a short-term rental. So we had made our intentions to the city known at every juncture. My husband said he was talking to them in October of 2022. Our contractor was talking to Lisa in October and November of 2022. In May of 2022, when we purchased the project, or we purchased the property, it was contingent upon approval to be a short-term rental. And then we were actually preparing, had our contractor not, misrepresented the services he was going to provide for us and taken advantage of us. We were planning to be open for last summer. So I actually launched the website, I believe in March of 2023. It was concurrent with the filing of the business license. We have an Instagram account, which now has almost 1,000 followers, that has been in existence since we took possession of the house in June of 2022. We've had commitments, hundreds of thousands of dollars of people who had soft reserved dates for both this season and last season. In fact, on June 24th, we were supposed to have a 7-day stay for a wedding party using the entire building that would have netted us somewhere around $28,000 of revenue that we no longer have because we've been denied our due process and we've been denied something that the city greenlit us to do. My husband and I have been long-term time tourists of this area. During the pandemic, I made a decision to close my luxury wedding and event planning company that I had owned for a better part of a decade. Coming as entrepreneurial people from a big city who wanted to embrace everything that Northern Michigan had to offer to give the accommodations that we had been looking for ourselves. Out of love for the city. And I don't know if any of you have seen our website or read any of the material on our website, but essentially it was a love letter to the city. And I completely understand, it's having come from Chicago, having been here in person, and I'm so glad we purchased a home first and then purchased the short-term rental. Because obviously coming from Chicago, there was some learning that needed to be done in terms of the housing crisis here. And I think that's only something you can fully appreciate as an outsider when you're here. We have agreed with the previous law that was applied to STRs, though it doesn't mention STRs from the very beginning. And when we moved here, it was actually, we were having trouble finding a house. It was COVID time. And our real estate agent was either looking for a rental that we could live in temporarily or a new home. And it's dismaying because we don't represent the type of short-term rentals that would take away from housing or be in an appropriate area. We bought in an area that was zoned for this business. We met the letter of the law when we purchased it. And we are a fully fledged LLC. I have 10 years of luxury hospitality experience behind me. My husband was going to join me. He's a teacher in Pellston. He was going to join me to run the business together once we were opened. And it is immensely discouraging when I feel like the intent of the new laws were passed had nothing to do with this business. We picked an appropriate place. We went to the city for permission. Had the city not given us permission, we would not have bought the property. Truly. So we would just ask that you would understand that we not only meet the standard for vestedness, but that aside, there are many other facts in our favor to prove that we cared about Petoskey and we cared about the law and just allow us to continue our project. I also want to leave you with, my husband and I are not professional developers. We're in our mid-30s. We came up here because we loved Petoskey and we wanted to embrace everything that is so great about this area. The entire building is themed to the area. And this is not just like we're a developer, a small thing for us. This is our livelihood. This has put severe strain on us. And it has had an immense effect on our mental health. And we've obviously had to deal with that through personal issues the loss of my father-in-law. So we just ask that that wrong is now made right. And that we're able to move forward with our lives.
Are there any more questions for the applicant or
Yeah, I'm
the attorney?
circling back to this permit. Have you filed now for a permit? Did you file as soon as you did not?
So
Found out you didn't have a permit, did you file then? And can we see that application?
So we brought the city, we actually did, our contractor actually had to submit on our behalf. So one other thing I want to point out, and this is actually given to us by Emmett County, is because we are a commercial property, we cannot submit the permits. They have to come through our contractor
Or an architect?
or an architect, which our architect that we're planning to move forward to backed out when this happened. So we've been on a complete pause since we stopped construction in, I think, July of last year. And nothing has moved on the project since then. However, the file for the permits have been submitted on the Emmett County website. You can access them.
Okay.
And I believe we're up to date with everything with the county. I also want to point out that we invited the county in September of 2023, I believe it was, or September 2022. After we had parted ways with our contractor, because it was important to us that everything be looked at with the county's eye.
So I'm asking these because to your point, it's all about vested interest. And were any inspections? Did any inspections, we have inspections made with your previous contractor under the permit that we're being told doesn't exist?
So
Because you're changing the use of the first floor from commercial.
absolutely.
So there should be, so been inspections.
So I was under the impression, based on everything that was given to us from both zoning and Sarah Back, that having a short-term rental, as long as you met the zoning, there wasn't, like, we didn't have to go before the planning commission. There weren't all these steps. We were told that we could not apply until the project was finished. But
For a license to operate,
sure,
but that's not a building permit.
I understand.
Okay.
So, and again, obviously, we are new to the area. This is the first massive project my husband and I have taken on, so I'm gonna give you what my understanding is from the county. So there are two types of permits that we're talking about here. There are Emmett County permits, and then there are City of Petoskey permits. City of Petoskey permits, to my knowledge, the only permit we needed to seek, other than a business license, which we did obviously seek well in advance of the change of law, was a change of use. There are text messages that are exhibits. They're in the first appendix from our contractor to us. I think they're in October of 2022 that say that he got approval from Lisa. We were under the impression that that permit was not issued, and he said he had the permits. We were under the impression that that change of use permit had not been issued just because he had misrepresented so many other permits to us as well, the county permits. But it wasn't until we watched the February ZBA that Lisa stated when very first introducing us to you guys that she did a change of use for us. So we are operating just off of that record.
So in February of what year?
That was this last February 2024, your meeting. So we applied in the end of February to be heard originally in March. At that point, we had reached out to Lisa only to say, hey, we're planning to apply for a ZBA. We had not decided whether it'd be administrative review. We had not said it would be a variance. We had not given really any information. So we were both a little bit surprised when it was brought up before our application had even been submitted, because she gave you a premise for the case that had not even been applied for yet. And during that conversation, it is on the recording, it's at the very end. I believe it's actually cited somewhere in our memorandum as well, with the link and with the appropriate citation. Lisa said, I did a change of use to change from residential or from commercial to residential. So I can only, because I have not yet seen the document produced via FOIA, I can only go off what I saw at your own proceedings, if that answers your question. So the only permit that I'm under the impression we needed from the city was the change of use, a zoning permit, which I believe we have. And the change in the property would have followed that. And if you refer to the text messages, you can see that as well. And then everything that needed to be done with the county I think parted ways, sorry, it's been a very long slog, this entire project, but we parted ways, I believe, with our contractor in either late June or early July of last year. We had asked them for permits maybe 10 times, so we just assumed that there weren't any, and we reached out to the county to make sure that the permits were there. When we learned that from the county that the permits did not exist, we invited, I believe Marty came in and did a tour, an inspection of the property with us to point out where we might need to rip stuff out that would need to be redone. And honestly, at that point, he's like, I don't actually see anything. You guys can probably just submit the permits. We'll have an inspector come out to verify that everything is up to the code, and then you'll be good to go. Unfortunately, then shortly thereafter, just a few months later, while we were working through the process of finding an architect, the citation came up and all of this started, which kind of put that to the wayside. But I do want to point out that we have not done any work since summer of last year. And we were visited by a county inspector who told us the city sent him in, I want to say March. And he had us apply, and our new contractor, who has not even done any work for us, submitted the applications on our behalf. So the files have been opened under the county. The county somewhat also intimated that there was also already a change of use, and he was just did a look through to see that we had in fact initiated that change of use. But again, until we get the FOIA records, I'm unable to produce that document. But we have requested it. Apologies also if I'm long-winded. I have ADHD and I was not prepared to speak tonight because I'm very emotional. So I'm just trying to, there's obviously a lot of documentation because there was a lot of contact with the city in the past couple of years.
Let me ask, were you aware?
Bill,
Oh,
thank you. Yeah,
Were you?
thank you.
are we live?
There you're good.
Okay. At the time of your purchase and beginning of your dealings with the city, were you aware of the city's ongoing consideration of revisions to short-term rentals? It was,
Not
yes,
No, actually, not in any capacity that would have affected us. So interestingly enough, our real estate agent, Cam Braddock, actually owns a grandfathered residential STR. We had worked with a previous real estate agent before bringing Cam on. And the reason we switched to Cam was because Cam had a better understanding of what we were looking for in terms of what the zoning would require for us to be a short-term rental. We made verbal offers on 414 North Wakazu, which honestly did take housing away from people, which is part of the reason we passed and never made an offer on that and ultimately chose this building. It not only fit the zoning, but it was really important to us that it did not take away available housing that was already in use. The owners of the previous property were no longer full-time living on top, so that unit was actually, I believe, being short-term rented under the table, to my knowledge. And then the downstairs was their business space. So we felt good about that because we knew that there's also a simultaneous lodging shortage, especially someone who comes from a luxury background, especially in pet-friendly luxury and large-scale accommodations. That was the niche we were going for. That is the entire business model. So we felt good about starting.
Could you just stick to the
Okay,
questions?
sorry.
Ask these
I'm sorry.
Like getting.
So the point that I'm trying to make is that, I'm so sorry, I just lost my train of thought.
No, is the answer.
you purchased the property, you said, in 2022.
Correct.
At some point,
21 is what I saw in the document.
Yes,
April 2022.
okay, and
we moved here.
April of 2022. Some point in time after that, you did become aware, did you not? That there were ongoing discussions by the city and new zoning ordinances on this issue were being discussed for potential implementation.
Sure. I'm sure
When was
that.
that you became aware?
I'll let John address that. I'm sure he has the specific dates of the interaction with that. I'll just say from a legal standpoint, they can only operate under the ordinance that applies at the time they're working. They have no legal duty to anticipate a change in ordinance. So as to when that is, I'll let John speak to that. But from a legal standpoint, the ordinance that matters is the one in effect at the time they're actually doing the work.
So if we could look in the packet is the business license that was applied for. I have a copy here if
Just cite to it, just describe it to us.
I can't recall the exact exhibit. It's the business license. So the business license, if you look at the very bottom of it, is paid for. And Sarah makes a note on 3/15/23. It's March 15th, 2023. It's then approved on October 16th of 2023, also signed off by Sarah. That's a difference of 6+ months. Now, having come here from the city of Chicago, we come in, we pay for our business license, and our understanding is we're in the system. We're not aware that the city clerk is going to contact us 6 months later and say, by the way, your business license has been sitting on my desk. I'm going to give this to you now, but by the way, just because I'm giving you the business license, it doesn't mean that you can run a short-term rental business. Oh, by the way, the laws are currently in the process of being changed and there's a moratorium. We found out that these laws were being changed midway through them being changed when that business license was finally given to us after we had also been issued a citation for running an illegal short-term rental that wasn't open. So actually the process for the discussion of the short-term rental ordinance change, I believe, was occurring in February of that year. A property on 315 Mitchell, 315 West Mitchell Street, which is actually within 300 is it feet or yards? It's our neighbor across the street had also had requested a hearing on the possibility of becoming a short-term rental. He eventually decided not to pursue that route, but we received no notice. When the city started to begin the process of changing the ordinance, or at least discussing it, they were, again, well aware that we were in the process of redeveloping the building. We were never contacted. That makes the business license being withheld, even though it isn't essential to what we're discussing here today, that makes the business license being withheld for 6 months look very curious. And so had we been notified, whether it's through a, public notice that was due to us, or simply notified in any manner, it certainly would have changed things.
At some point, can we ask Lisa questions?
Oh, yeah, absolutely. I'd like to just finish. Does anyone else have any questions for the applicant before we move on? Okay. Right before I do that, I'm just gonna go to any public comment?
Sure.
And then we can take it
Thank you
back.
for your time.
Thank you. Are there any public comments on this particular application? Anyone online?
Not seeing anything.
Okay. Then we are closing public comment, and we will bring the discussion back to the board. And at this time, and be okay.
So-
Ask some questions.
So much of this, as the attorney said, really hinges on their presumption that they have a vested interest because the ordinance changed. It's my understanding that prior to the ordinance changing specifically for STRs, and I'm asking you this, Lisa,
Mhm.
there was still no short-term rental allowed in the B3 district on the first floor. There were motels, and so could you explain that?
So prior to this ordinance being established,
Right.
short-term rentals, vacation rentals, hotels, motels were all kind of clumped together
Right.
and followed the ordinance per the zoning district.
Right.
With that being said, the B3 district states under special condition uses that a motel is required to go before the planning commission for a special condition use approval. That is why 315 West Mitchell had requested a public hearing. However, no notices were sent for that public hearing because within an hour of the request to the newspaper to publish that notice, it was then requested that it not be published. The paper confirmed it would not be published. However, they did go ahead and publish it. So unfortunately, there is record in the newspaper that there was a public hearing on that date. However, there was not. The applicant opted to wait and not pursue that path at that time. So that to address why there was no public notice sent. That being said, B3 district does require for a motel, which motel, hotel, vacation rentals had all been treated the same under the old ordinance, would have had to go before the planning commission for special condition use approval. It is not a principal permitted use.
So it's not a principal permitted use.
Correct.
Thank you.
And
That's what I thought.
just for my clarification,
Keep your thing on.
this request did not have a full hearing in front of the planning commission?
This,
The request,
for us today, they did
That's
not, correct.
I was wondering why on April 28th, it says in here that the city confirms that short-term rentals are permitted on that property. It doesn't really say first floor, second floor, it's not specific to that, but you know, how does that fall into the situation here?
I would defer to Rhonda. City's
Rhonda. Oh, Rhonda.
attorney. I wasn't part of that whole
Mhm.
conversation.
I would state, I also was not part of that conversation. At least what's been presented tonight is that there wasn't a differentiation between first floor, second floor.
So who was that conversation with? I mean, besides,
I believe that was an email between the Realtor and Sarah Beck, the city clerk.
okay,
And I don't know the. So I think one thing that may be confusing, Sarah's the clerk. Sarah approved a license, right? That had to be forwarded to you for full approval. She approved an application for the short-term rental.
She received the application. It then goes to the zoning administrator, public safety. And she is basically the person that initiates and then compiles everything.
So her role was to acknowledge the application.
Correct.
And then it was sent to you and you said it's allowed on the second floor, but not on the first floor per ordinance.
Correct.
So
There's a gap. Can you turn your microphone on? Sure.
Sanan?
Yep.
There's a gap between the initial discussions, which I'm hearing that there has been approval before the zoning ordinance was passed. And that seems to be the basis of discussion here, but we had no permits. So we don't know what it was really applied for. We have heard that there has been that there is a permit for change of use, but we have not seen that paperwork. So there's a big gap. And based on when they submitted the application, the ordinance had already passed. So it's clear that they did, you know, how that was agreed to, but all the stuff that happened beforehand is all hearsay. It's all timeline and not a judgment statement. I'm just saying, we don't have any paperwork to support that other than a cashed check. So
I can tell you what came before me, and that was
where's the zoning approval permit that the applicants are saying that they have been told exists?
the only record of a zoning permit issued for this property in the last 12 years was the one that I issued in January for the second floor change of use from residential to short-term rental. That is
Okay.
the only zoning permit on file.
Okay. And do you see, well, we've already established there was no building permits applied.
That's my
for.
understanding.
Okay.
Was there,
Turn your microphone on, Kate. Thank you.
so was there between the Tierney's and the purchase of the property, wasn't it a medical marijuana?
No, it was approved for a medical marijuana provisioning center that never came to fruition.
Okay,
There was an electrician and his wife had a stationary printing
The Tierney's.
facility. No, this was after
After the
the
Tierney's,
Tierney's.
okay.
They had that on the first floor as their commercial operations. There were two separate businesses, and then the upper floor was residential. I did confirm with the city's assessor, and that is what they have on record as well, is that first floor is commercial, second floor was residential.
right. And prior to the change of the zoning, in order to do a short-term rental, you would have to go in front of the planning commission.
That's my interpretation of the ordinance, correct?
Or a motel or a whatever.
Yes, because they were all categorized in the same.
Okay.
Does anyone have any more questions? Right now is our chance to discuss it amongst the board. This is, as I said, a little bit different. We don't have to go through a checklist. It's really just saying, do we support the administrative decision that Lisa made, or don't we?
Well, I have a question,
Okay.
and I can't find it right now, but when I was reading all this, there was reference to what the attorney called substantial work. I can't remember exactly what the terminology was that they did work on this. And when I read it, it was based on a case in Saginaw or somewhere like that. I can't remember. And I wondered, you're telling us that's a law, is in fact that correct? You know, you understand what, he's saying that's a case that's come up before and it's precedent because they had to deal with it. And I just wonder what the verification of that is.
I wonder if that's beyond the scope of this board to determine the veracity of
Well,
the
that's
claim.
the base of their claim is
Well,
they need substantial improvements to the property. So they should be grandfathered in. So I think it's important to what we're talking about here.
We'd have to get a legal opinion.
That's what I'm asking.
Rhonda, do you mind?
Sure. My understanding of the law in this area, and I would rely on the Supreme Court of Michigan's decision of Heath Township versus Saul, which was entered back in June of 1993, is a critical component of a substantial character reliance argument is the obtainment of a permit. In the Heath Township case, the defendants, they were talking about when they began their construction and whether or not it was a substantial character, but it was noted that they failed to obtain the required permit prior to the referendum that changed the law. And the court went on to note that it's very important under Michigan case law, a building permit or its counterpart, a permit to commence operation, is an important factor in deciding whether or not there exists a vested right in having that use. In this instance, we don't have an application for an STR. We don't have a building permit. We don't have a special use permit request. None of that is at least even submitted prior to the moratorium being entered and then the subsequent change in the law. And that's one issue. The other issue that I have is I understand that there was work done on the property. What's not clear is how much of that renovation work was for the second floor versus the first floor. And of course, for purposes of our discussion, the first floor is really the critical component here.
Anyone else have anything they'd like to add? If not, we're ready if someone would like to make a motion. The motion would either be that you move to either reverse or affirm Lisa's decision.
I'll make a motion to affirm the decision of the zoning administrator in case 874.
I would ask too that the board, when it makes this decision, state the basis for its decision in the motion.
Oh, okay. Based on the evidence that a vested interest is not proved, not clearly proved, and that short-term rentals on the first floor were not allowed prior to the new ordinance nor after. Is that clear enough?
I would add to that.
Yeah, I mean, this would be fine.
I talk really loud. I would add or clarify, and I'm not good with words, that whereas it's not been, that to change the use to a short-term rental needed to be brought before a planning commission, that it was not a right of use, it would be a non-compliant use in the.
It's not a use by right.
It's not a use by right, and it was a non-compliant use when they bought the property. And whereas they had verbal assurances, we've seen no documentation from anyone that there was ever any written approval or any planning commission application was made.
That's good, Eddie.
You
I
approve that amendment?
your yes, changes. Thank you.
All right, we have a motion. Do we have a second?
I'll second it.
Okay. Could you read back the motion, yours?
Read it back.
Let's do our vote.
Okay.
But in essence, the motion is to affirm
Affirmed.
Lisa's decision.
Okay, so Marshall,
Yes.
Stein,
Yes.
Brown,
Yes.
Hendricks,
Yes.
Hibbs.
No.
Motion carries.
Next piece of new business is case number 875. It's a lot area variance request to allow the construction of a 12-unit apartment complex on parcel 52-19-6-400-156. Lisa, if you could give us some background.
Sure, the subject property is a vacant 18,139 square foot parcel on the south end of south of Sheridan Street on a dead end portion of Petoskey Street. The property was rezoned from R3 single family residential to RM2 multiple family district in 2023 with the intent to construct an apartment complex. The parcels to the west of this property are zoned RM2 and the parcels to the north, south, and east are zoned R3 single family residential. According to a 2004 boundary survey, the parcel had a gross lot area of 24,810 square feet and consisted of 4 lots with a 32-foot wide easement to allow access to lots 1 and 4. The easement is currently used to access a parking lot at the rear of an adjacent apartment building at 214 East Sheridan Street. In 2015, the property was split to allow Lot 2 to be sold as a standalone parcel. And according to a 2023 site plan survey, the property split reduced the gross lot area of the existing parcel to 18,139 square feet. Of that lot area, 3,017 square feet are unbuildable due to the easement. So therefore, the net buildable area of the parcel is 15,126 square feet. Per section 1600E of the zoning ordinance, the maximum number of one-bedroom units allowed for this parcel is 7. And the applicant is requesting a lot variance of 6,374 square feet to allow for the construction of 12 one-bedroom units, which is 5 more than is allowed per the net area of the parcel and the ordinance.
Okay. Is the applicant present? Please, give your name.
Zeke Budnick, 3688 Caltech Road, Petoskey. Just a few little brief statements here. I'm looking for a relief from the existing number of units allowed by the zoning, existing zoning criteria to be from 7 to increase to 12 single bedroom units. The units will be for workforce housing, and we do previously own 28 units in the city of Petoskey that are for workforce housing. In my opinion, I believe it's in this area, it's an exceptional use of this land. The lower level would be like a split level with egress windows to adjust for height, so I don't have to go for a variance for the height. I guess Lisa could attest to this, the building footprint, I meet the setback, the height requirement, and the parking requirements for the square footage. I can fit that all in. The existing on this land, the property to the west, where the building's going to sit, there is a larger garage to the west of it, and then there's an existing apartment. I believe that's a 6 unit or a 8 unit. I'm not sure what that is, adjacent to that. And then, adjacent to this property on the east side is Petoskey Street, which is a dead end road, which virtually there's hardly any traffic that goes down that area. And the building to me is in a good spot for workforce, again, for being able to walk to downtown area for the workforce tenants. So, and I guess if you ask me, if there's one thing that the city needs, there's workforce housing. So that's what I'm trying to accomplish. So thank you.
Thanks.
Don't leave.
Oh, was I-
Susan, sorry.
I know, but turn it off. Just leave it on. It's not noted on either the site plan or the survey. Lot 2 is the L-shaped lot that's to the, I guess, north of,
Yes, yeah,
and you have lot 1, lot 4, and lot 3.
correct.
Okay, and the easement, is there a square footage of the easement?
Yes, that is
6,000, no, it's
3,017 square feet.
and what is this about lot 2 split? I mean, that really doesn't have any bearing on this discussion, right?
So essentially, they owned all 4 parcels at one point in time, and they sold off one of the 4 parcels.
So
So that does impact the square footage, what they did own.
But not for this application, it doesn't have any bearing to this
It
application.
changes what,
Correct.
well, it does because of that easement that runs through. It's now, it allows access, so it does impact it in the sense that had they owned all 4 parcels, they own the adjoining parcel to the west.
But they don't.
They do.
Mhm.
There's currently access from Petoskey Street to the parking
No,
lot.
they don't own all 4.
Correct, you're correct, right,
My
yes.
wife and I are
it's family owned. My wife and I are gonna purchase this contingent on this right here. My father-in-law had sold this after his wife had passed away, and he was not gonna stay in the rental business, and so we started taking it over. So contingent on approval, we will purchase the property from my father-in-law.
Lot 1, 4, and
Yes,
3.
and also there's a 7-unit adjacent to the east also. You'll see that it says Kelcheck Properties.
Right.
We own that too.
You
So,
now own that?
not yet. That's contingent on
Okay.
all of this in the purchase.
I have been down the street.
Mhm.
I did go look at
Oh, did you?
it. Yeah.
Well, you're, excuse me.
Oh, you're on, Bill. No, you were on.
Was I?
Green means go.
Your father split off one of the lots.
One of the lots, yep.
Your father or father-in-law?
Father-in-law,
Father-in-law.
father-in-law, father.
He's the owner of all this acreage.
Yes.
He split that off.
Mhm. Right, after his wife had passed away, the neighbor approached him to sell it, and at the time he had no use to develop anything, so so that's where I come in, that I'm gonna find.
Do you have any comment to the factor or the criteria that is normally looked at by the board that the variance request was not created by essentially the applicant?
Right.
What would your response to?
Well, my response would be that I'm the liaison for the applicant. I'm going to be the future owner of this go through. I wish that he would not have sold that because it does create, a problem in this situation. So had I known, what the future, we were not part of it at that time when he sold it, so.
But you acknowledge the recognition.
Oh, yes, absolutely, right.
7 units are within the existing zoning terms.
Mhm.
Why not just comply by limiting the construction to 7 units?
It has to do with economics of building cost, and again, more workforce housing for the community. And I can fit it in a way that it still meets the setback requirements, the height requirements, and the parking requirements.
Did you do any calculations on if you had done larger apartments, whether you could meet the current use?
It works out that there's more single people that are renting in this.
That's a business decision in the initial planning stages. Did you do any calculations to see if you did 2-bedroom or? I think that
Oh,
was.
right, yeah, and I believe in the beginning, but things have changed after, I think there was a 2-bedroom and then the rest were single bedroom. But once you start building and you introduce the sprinkler system, for economic reasons, the sprinkler system is one of the most expensive parts for building. And if you do 7 units, your cost effectiveness goes away. So it doesn't make worthwhile to do a 7 unit in this case as a business standpoint.
I have a question. Do you have funding in place to do workforce housing?
For workforce? No, not for workforce, but
So there's no, despite the fact that you might want to, there's no guarantee that
I don't know.
affordably for workforce housing.
We have every one of them is in the restaurant business, so that's why I base my opinion on workforce housing.
So, you asked earlier how many
Jim.
square feet the.
Sorry, I'm trying to-
It goes up by itself after a while. How many square feet was the easement, did you say?
3017. 3017.
3,017? So is that taking out of what the usable building space is.
Yes,
And that's just a driveway for the. Okay,
Well, you're planning on using that to connect to
Yes.
your parking lot as well.
Does anyone have any more questions for the applicant? Okay, thank you.
Thank you, and thank you for your time.
Yep.
thank you.
At this point, we'll open discussion up to public comments. Anyone have any comments to make?
Yes. There is.
Well, this is public. Whoa.
We're on board.
We can close. If there's no public comments, we can close that and now we'll bring it
Comments.
back to the board and we can discuss this amongst ourselves. So go ahead.
Can I just hear you talk? I can speak real loud. Well, the microphone picks it up, sorry. But I want to make sure that what I'm looking at, I went to the GIS program to. Some people here know I ask questions, but I usually catch them after the meetings.
If you could give your name and address.
Laura Steele, 1645 Standish Avenue, Petoskey. So I'm in the same ward as what this is, I think. All I did was go to the GIS program and I tried to figure out what it was he was talking about, but Petoskey Street on that side of Sheridan has a lot of activities going there, and it looks like people are really close to the road, and I just had some questions about and clarification, please. We're going to use Petoskey Street as your access. Okay. And then the name on that property right now is Kalchik Developing. Okay. Then I have the right one. All right, that's what, and the density is where I had some questions too, because of you all know that we have a couple of apartment complexes being built now. One on Standish and one on Emmett Street. And with not knowing whether or not if this is really going to happen yet, I think this might be a little premature to go for it. Those are all, for specifically the one that's on Emmett Street, it was being built for workforce. I just was concerned about the congestion. That's all. Thank you.
Thank you. Okay, at this time, we'll close the public comments and discuss the case amongst the board. Anyone have any initial thoughts?
I do. So one of my thoughts is that the planning commission is currently involved in a 2-year process to redo zoning across the city, and may in fact change density requirements, or may not, but that hasn't happened yet. So I think if this is approved, it's really a spot zoning approval, which I question. And given that, the planning commission approved the 7 units as being suitable for that piece of property, and the difficulty lies not with the property, but with the developer's decision, I think it's challengeable. So.
Hey, I'd just like to comment. Now it's me, turn on my microphone. Just want to comment, this has not gone before the planning commission as an apartment complex.
I thought,
The request went before the planning commission to rezone the property
okay,
because it was single family residential, and the planning commission approved, as did city council, to rezone the property to multiple family.
okay,
with the intent to build an apartment building. There was no other discussion at that point. It was just,
So where did the 7 units come from then?
that's based on the
Was it the
zoning and the area of the parcel.
Okay, I get it. Sorry, I misspoke.
No, that's okay.
Anyone else have any thoughts?
Well, you know, I understand, exactly what Kate means, and I also understand that to make a project feasible financially to do it, you know, obviously the more units you can get in there, the more practical it makes it. I wondered if there was any room to include the easement into the square footage and maybe not allow 12, but maybe allow 9 or something like that. Is that feasible? Anybody think that's?
I mean, we are certainly empowered to make whatever variance we want. It can be a full variance, we can deny it, or we can do something
Is that
in between.
Is that a bad thing to consider the easement part of the available lot, you know, that's available to cover, or is that automatically taken out of the equation because it's an easement? You know what I'm saying?
Well, it's not buildable.
Right.
That's why it was not included, is because it's not a portion of the property that could be built because of that easement.
Okay.
And an easement is an easement. I mean, you're asking, is an easement in perpetuity, right?
Right. Right, and is that
Neither party is allowed to construct within that.
right?
That
I mean,
area,
I just
so
wondered
that's
if
why
there
it's
was a
limited.
way to consider that as part of the total envelope, but I guess what we're all agreeing is that no, it's not, because it's a driveway, right?
Correct. That's why I did not
Okay,
provide it in the
I
calculation.
just throwing that out there, devil's advocate, you know?
Any other comments? If not, we can move on to our checklist if people want, or we can keep talking.
I wrote down here standard of use variance. Lisa, and you may have to, there's a lot I've been reading. Do you know where I read that? Was it in chapter?
So a use variance is different than the request before you. The request before you is a lot area variance, so it's asking you to allow them to build more than what is allowed based on the size of the parcel. A use variance is where they're asking for a use that is not permitted per the ordinance. So yeah, I don't even know what to throw out there, but it basically, if he was requesting to create
This is a not use.
a retail
this is
space.
A non-use variance.
Correct, this is not a use variance, this would fall under dimensional, correct?
Okay.
As far as. It's just a little bit different, we're just going with different this year, in that it's lot area versus dimensional, in the sense that dimensional is typically setbacks. Lot coverage, height, as Zeke had pointed out earlier, he meets all of
He
those.
meets all of that.
He meets all of those, the part he does not meet is the requirement for square footage. To build that many units.
I have a comment. Just two things. One, as we all know, the request for the variance ultimately self-created by the prior lot split, generating a lot of these sizes that are left. And therefore, secondly, the existing code, I believe we ought to think about our fidelity to application of the existing code as the premise. And there needs to be a compelling reason to deviate from the existing ordinance. This is not just 100 square foot difference that we're facing. Both because of the size of the requested variance and because the variance request was essentially self-generated, I would oppose the request as it stands. I would fully support, of course, the applicant's right to build on the property as he's entitled to. But within the existing zoning ordinance, which was, I guess, 7 units. That would be my 2 cents. Two?
So do we have, having not done one of these before, a motion and then we fill out the form, or do you fill out the form and then have a motion? You do this first, okay.
I can find that.
Hmm?
I can't find mine, so you.
Oh,
you
well,
go-
sure.
You gotta do it.
Sure, Lisa has it.
Would you like mine?
No, I was just kidding.
Oh, okay. Say I do have one.
He's presuming I will share. I will share.
Are you gonna take us through there, Chris?
Why don't we go through the checklist? Is everyone ready?
Yep.
Okay. First, will strict compliance with the dimensional requirements of the zoning ordinance prevent the applicant from using the property for the permitted purpose? A variance is granted for circumstances unique to the property, not those unique to the owner.
So that would not support the variance, right? I mean, do we, I don't know.
Yeah,
We just check it.
sort of, people can offer their opinions about this, but
Okay,
I would agree that does not support the variance.
I would agree to.
I agree with that.
The second one, is there a way to accomplish the same purpose without a variance or with a lesser variance regardless of convenience or expense? The ZBA considers the property not issues with the interior of the structure.
Well, we discussed 2 different options. One is to include the easement in the square footage, and the other one is, are there other ways to build on that property? Which is the second part of this statement, so that's.
Build something that.
Yeah,
would
that's,
imply.
yeah, that's strict, so I'd say, no.
Me too.
me too.
All right, is the need for the variance due to a situation that is unique to the property and would not generally be found elsewhere in the same zoning district? The situation is often repeated in the same zoning district, then the variance request should be denied.
Well, it isn't due to a unique situation of the property. Correct? The asking of the variance. But
Yeah, we're talking about like peculiarities about the site.
yeah, there's
or
nothing
the-
peculiar about this.
Yeah,
Yeah, it's
And I don't
not
think
a
it-
big enough lot for 12 units.
Right.
Right,
No.
so,
Okay. If granted, will the variance uphold the spirit and intent of the ordinance and be fair to neighboring properties? There are reasons the ordinance was adopted, and those reasons should be respected and upheld.
This one I would say yes to.
yes. Yes, that it supports the variance?
Anyone else have
I
thoughts on that?
don't think it would.
I don't.
Support the spirit and intent of the ordinance, which is, limiting.
As a-
Yeah, I'd say no.
And last, has the need for the variance been created through previous action of the applicant? The appeals board is not responsible for bailing out an applicant who created the need for a variance.
I think that one's very
That was
clear.
obvious.
That the existing owner split off that first parcel and thereby limited future builders. That's just the reality of it. That does not support the variance, in my opinion.
What was the comment?
You're good.
What was the comment that that the gentleman here is not the applicant? There was a statement made that he's not.
He is the son-in-law of the current owner. He stated that the purchase, is that right, Zeke? The purchase of this property and the neighboring Sheridan Street apartment complex or building are contingent on the approval of the variance.
So the applicant in this instance is the person that owns the land, not the person who stood the applicant.
Correct.
Okay. So it has been created by the person, the actions of the applicant,
Correct.
the variance, the need.
All right, well, if someone would like to work on a motion. Or if someone already has. one.
I thought Bill's comment before was a motion. I think it could be a motion.
Motion. This is kind of our template.
My motion would be that the request for the variance be denied. For the reason that the applicant created the conditions that are now before the board, but splitting off the prior lot, rendering the current property to its specific dimensions, and that the spirit of the zoning ordinance limiting the number of acceptable units on this parcel to 7 is appropriate, and there's no compelling basis for varying from the zoning ordinance restriction to 7 units.
Support.
Call for a vote.
Hendricks,
It was to, I support.
Nibbs,
Support.
Marshall,
Support.
Stein,
Support.
Brown.
Support.
All right, the motion passes, the variance was denied. Okay, the next.
One comment.
Sure.
I appreciate, I know it's a hard job, you all, it's a tough position that you're in.
It's not. It's not from you.
Thank you.
Buy the other piece of land.
All right, moving on to public comment. Do we have any public comment on anything? Okay,
I don't know if it would be or
well, try.
not. Well, instead of the couple that was here. One of the first things I did was I contacted the city for my property. And I said, what am I supposed to do first? Because it is hard. And that's when I learned about the Petoskey County confusion on who does what, when,
Mhm.
and that was the only thing that helped me realize that I had to make a list and do things. I can see it happening with more people. You know, where it's just not totally clear. But then being in an unfortunate situation where they're told one thing and it doesn't appear to be the actual situation. Yeah, that was.
Mhm.
That's my comment.
All right, thank you. Thank you. All right, next, number 6, updates, any updates?
So this is a little late in the meeting, but welcome Susan Stein, your new zoning board of appeals member. Mary Clinton's term expired April 1st, so she decided not to reapply. So Susan was kind enough to join us on this venture. So just wanted to say welcome, thank you. And at the next meeting that we have, we will have on the agenda the appointment of a vice chairperson. So if anyone's thinking about their interest in becoming
What is the vice
Vice
chair
chair?
do here?
in
Other
the-
than
in the
sit there?
absence of the chairperson, you would be acting chair, and then the main role would be reviewing minutes after the meeting for content, making sure everything is accurate, and then, you know, providing any corrections or changes that you feel are necessary prior to it going to the board at their next meeting. We do have a request for July. It is for a use variance. There's another new one. So I have received that application. The deadline is noon tomorrow. I have not heard of anything else that potentially would be coming before you. So with that being said, July 2nd is the next meeting date. If you guys can check your calendars and see if that does or does not work for you, and let either myself or Christine know as soon as possible. Because publication does have to get to the paper and notices have to be sent out. So if you do know that you won't be available, please let us know as soon as possible. And other than that, that is all I have for updates.
Okay. I guess that's it. Do we have a motion to adjourn?
So
So second.
All right. We're adjourned.
So